Hello and welcome to Regional Counsel, presented to you by the Singapore Academy of Law. My name is Nicole and I am your host for today. Regional Counsel is a series of short video podcasts on legal content catered to in-house counsel who are new to ASEAN regional work. This series is not meant to be a deep dive, but to equip in-house counsel with tips and tricks from experts of Indonesian law themselves to navigate the challenges faced when dealing with jurisdictional specific quirks. In today's episode, we'll be delving into litigation with Dr. Santy Kouwagam, researcher and postdoctoral fellow at the Leiden University. Hi Santy, good morning. Thank you for joining us today on this podcast. Really glad that you're able to join us today.
Hi, Nicole. Thank you for inviting me. Very glad to be here.
Thank you. Okay, so Santy, we understand that you've practiced as a lawyer in Jakarta before you became an academic. Will you be able to share a little bit more about your experience and your work on Indonesia law?
Yes, thank you. So I'm Santy Kouwagam. I used to work at a law firm in Jakarta. The law firm mainly did corporate litigation. And then I went to Leiden to do my PhD. After that, I taught at various universities like University of Amsterdam, University College Roosevelt, and also in Leiden University. And mainly I taught contract and tort law, also European law, and comparative law. Uh, I studied law in my hometown
Mm-hmm.
and also in the US. And then during my career in Jakarta, I used to deal a lot with Singaporean law as well. So I am familiar with the culture and the basic of the Singaporean law. So I hope I can give you uh, some insights into Indonesian law.
Thank you so much, Santi. And I read a bit of your book as well. So you published on land conflicts in Indonesia and the strategies. So we're hoping to distill from your knowledge as well and your experience doing research and also, litigating in Indonesia on these various issues. Are there certain types of outcomes that need a court judgment, for example, which you wouldn't recommend, using other types of dispute resolution processes? And in that tangent, can I just check with you for in-house counsel who are drafting contracts, and if they have cross-border transactions? So, for example, if they are obviously, based in Singapore or as a Singapore company, or if it's another foreign company and the counterpart is an Indonesian party, would you recommend that the choice of law be Indonesia, for example, and the choice of forum to litigate any disputes be Indonesia? Or should they try to negotiate for a more neutral forum, for example, and also for the governing law to be another law other than Indonesian law? Or would you recommend that Indonesia law be pretty easy to navigate? I mean, I've heard you on some of the difficulties and challenges in litigating in Indonesia, but I mean, based on your expertise, researching the laws of various jurisdictions, how would you say Indonesia law compares?
Yeah, I am torn now between the researcher and the lawyer in me because in my research
Let's hear both sides of views.
the conclusion that
Yeah, please share with us what you think as researcher and one as lawyer. I would love to hear that.
the conclusion that I drew during my research, I said in my book that one of the big problem that Indonesian law cannot develop to become, what we understand with Singaporean law, so straightforward, everything clear, because this corporate lawyer, the professionals, they don't go to court, so they don't uh, participate in making litigation a better field. So I argued in my research, I said, if we keep choosing Indonesian law, we all go to Indonesian court, then everybody can make a litigation practice that is better, because now it is exclusively the territory of the brokers, the fixers who don't actually play well in this litigation game. But yeah, being a lawyer, I usually see that if, for instance, an agreement, a contract that is drafted using English law, using Singapore law, with Singapore court as the dispute resolution body, the result is better, and it's really more preferable because um, you can yeah, you can expect better. There's less surprise. So that's where I'm torn. You also ask like which kind of contracts that you cannot avoid Indonesian law, and then that once again that has to be any kind of businesses that involves land. Any kind of land
Okay.
enforcement needs an Indonesian court decision. So you cannot do that with Singapore law, English law. So yeah, if anything, if the collateral is land, if it's a plantation, mining, or a factory that you need to, there is a factory building, factory land involved, then yeah, it's better to choose Indonesian law at the start. You could choose BANI, Badan Arbitrase Nasional Indonesia, as the dispute resolution body, because then you can still choose to use the language of English if there is dispute, but then of course it's still arbitration. You know, there's a one extra
Yes,
step
understand.
for enforcement. Yeah, yeah.
Okay.
Enforcement in Indonesia, of course, is still really difficult. And researchers already said that in Indonesia there are 5 steps of appeal. Because formally we have the district court, and
Wow.
then you go to high court, and then you go to the Supreme Court, and then if there is really special, you go to judicial review, that we call peninjauan kembali.
Ah,
Now in practice, the judicial review, uh, you can repeat it. You know, even if the law say, oh, at most you can only do judicial review once, but in practice people just keep continuing with the dispute. And then researchers actually say like, okay, these are 4, but actually when you get a favorable decision, if you need to enforce it, you need to go back to the district court to get an enforcement decision. So it's actually 5 steps at least to enforce an Indonesian judgment. So it's very long. Be prepared to be to be in it for years. So also, so in my book, I also say that this these years when you are litigating, often the cases keeps going in court, sort of like with one leg, but in the behind it, it's like um, it's like one aspect you can use to negotiate. That's what business people do. They go in litigation in Indonesia. They let it go. They hire a lawyer to go and keep appealing. But then in the background, they would reopen negotiation if there is. It's just one, like one point of their negotiation.
okay. I think that's something that parties, litigants everywhere, else also experience, because I've had experience in Singapore as well when litigating, and parties realize it's going to be so protracted, it's going to be a never-ending affair. They also open up negotiations at the side to see if they can settle the matter, because parties could sometimes be tired, right, of having to go before the courts. And like you mentioned, there's so many procedures, so many processes. Of course, the sunk cost of litigation has already, been there, but it doesn't mean parties cannot see eye to eye if they wish to, try to meet in the middle.
Yeah, be aware as well that in Indonesia there is a rule that you cannot actually withdraw a case. Once the court already,
Oh, you can't redraw any case?
yeah, that's when you compare it to Singapore, that's where I suddenly
Mm-hmm.
remember. In Indonesia, if your counterparty already submit their answer to the court, you cannot unit or you even if both of
Mm-hmm.
you agree that okay, we settle and we want to withdraw, that's not possible anymore.
I see. Okay. Oh, that's very interesting to know. I didn't know withdrawal was not possible.
Yeah, the court needs to make a decision. The court really needs to sort of approve that you settle in that point. So really the
Ah, I
negotiation
see.
period
Okay.
for in the first instance is only until the answer, and then yeah, and then you have to carry it out.
I understand. Okay. Yeah. Can I just clarify with you one point? I think earlier you mentioned that parties, the litigators, those that you mentioned, you called them litigators. Some of them don't litigate. So if let's say they bring a case to court and they don't show up, is there a concept of, for example, adverse inference drawn against a party who doesn't actually show up in court? Is that a concept that is known in Indonesia?
So yes, in the so it depends first in which states are we talking about not showing up. So in the in district
I
court,
see.
if a party continues not showing up, the court can declare a verstek. So
Hmm.
it's a unilateral judgment basically. So that's the
I
risk of
see.
it.
Okay.
You can not show up as a if someone sue and then you don't, but that's the danger that the court will just decide completely in take in favor of the plaintiff, and then yeah, and then you have to deal with that. So but in appeal and
Mm,
in the Supreme Court actually there is rarely a hearing, so you don't need to show up anyway. It's
I
it's
see. Okay.
you just draft a memorandum of appeal, memorandum of cassation, and it's all paper based. Only in rare situation that the court will
I see.
hold
Okay.
a hearing.
I see. Okay. So as long as one party, both parties submit the documents, the court is able to make a determination based on what is submitted.
Yes, and also this is where when I say that Indonesia doesn't have a formal civil procedure code, leaves a lot of gap, because this is the area where parties can play a lot about sending information. Like often we found cases that, oh, the court already decided, but we are not informed, so the time lapse to file for appeal um, already expired, because then so one way to do it, for instance, like they can go to the court and say, look, I have tried to inform my counterparty that there is this decision, but I cannot contact them. So can you declare now that this is now binding? And also from the other side, when a party wants to inform you to a decision, you can also avoid receiving the decision. So by avoiding receipt of the decision, the time lapse to appeal for the to file for appeal will not start.
Ah, I see. Okay. Yeah. So those are tactics that people play.
That's why it's really litigation in Indonesia is really play. That's what I found also in my
Yeah.
research. Just because the rules are so
Sounds very complicated.
yeah.
Yeah. And they're not codified right anywhere, as you mentioned. So I think, yeah, it's really opaque, I think.
And also that means that the only people who knows the rules are the people who perform the game.
Yeah. Oh my goodness. Okay, so I suppose, university students who are studying law, they don't actually know the rules of the game until they're in the game itself, right? And also for in-house counsel who don't step into court, there's no way they're going to know the game unless they have played it before and unless they know someone who does it. So that's where the complications and the challenges arise.
Yeah, for university students, I kept recommending that more and more students should go to the court to observe hearing, because they could also participate in seeing what the situation is, and they could also, you know, complain if there is something wrong, or suggest a better approach. So that I hope that there will be more and more practice requiring university students to go. And the Indonesian Bar Association also
Okay.
for a long time have a rule that before you can become a lawyer, you have to follow a more senior
Mm-hmm.
lawyer for at least 2 years to learn the practice.
Mm.
So maybe
Yeah, I see.
that's
Okay.
a way. There are ways
I
that
see.
they are trying to change that, but it's still slow.
It sounds like it's going to be a challenge. And also, like you mentioned, it's so informal. So whatever they see, may, for one court may not be the same way other courts or other judges would decide. And how, how lawyers manage to convince judges, to see their point of view may be very different depending on who the judge is and who the lawyer is in terms of their seniority and their standing in the profession. It does sound like, a lot of it is based on perhaps social capital and experience.
Yeah, you really put it quite clear there. Yeah.
Thank you. But I'm obviously an outsider to this. So hearing all this from you and reading your book has been very illuminating. So I do recommend that people read your book because, it talks about legal strategy, it talks about the different types of lawyers, the chain of command, and the complexities. Yeah. And I mean, just to follow up on that, I think you mentioned about a concept of zhengli or qingli, how do you pronounce that, in your book?
Yeah, it's a Chinese concept, Cheng Li.
Zhengli,
I
okay.
mean, is it in Chinese language?
I saw that in your book it's taken to mean something like good faith. But I'm not sure
Yeah.
whether there is a translation for that in Chinese. It does sound more like a gift of sorts. But of course, good faith is a concept that is known in English law, right? And also in the countries that
Yeah.
follow English law. So maybe you could expand on how this principle is a driving force behind legal enforcement of contracts, since we are on this topic.
Yeah, that's true. That's so when I what I found in my research, parties always refer to Cheng Li, like when they complain about their business counterpart, they say, "Oh yeah, he's not Cheng Li," or "We have to do this Cheng Li with Cheng Li." So it also means a kind of win-win situation, and also means good faith. And then in my research that I because this is quite, it has a Chinese language background to it. Apparently, it's a principle of Chen and Li. I'm not an expert on Chinese language, but
Oh, I think now that you mention, I think,
okay.
yeah, I think I know which words you're referring to. I think it's probably Cheng, which
Ah,
is sincerity, and Li, which is a form
okay.
of, a form of
Really?
like a gentleman sort of, a way
Oh,
of presenting yourself. Yeah, I
yeah.
think honor, perhaps. Yeah, it does sound familiar. I may be wrong, but yeah, it does sound like what you
No, I
mentioned,
think you got it there because that I know that it's a Chinese language, but it became a word by itself, Cheng Li, like one word in our Indonesian dictionary,
Mhm.
and it means good faith. So it's
I see. Okay.
the interesting thing is that I find this in the field. I find this in business people. They discuss this at length. There is always Cheng Li in the background, but you don't find it in court. You don't find it in any aspects of law. In Indonesian
Mm.
translation of the civil code of the criminal law, there is an Islamic concept of itikat baik. So itikat. So but it's still good faith is a concept that still is open for really broad interpretation.
Okay. So would you say in-house counsel also have to deal in a manner that reflects this principle of Cheng Li? Would that help them in their dealings with
Yeah.
Indonesian parties, and also in understanding of how things work?
Yeah, of course, and also you may have to invoke it when negotiating. Like, oh yeah, so the weakness of this concept is that you leave a lot of things unsaid because you said, oh yeah, we're just gonna do this business Cheng Li, which means win-win situation, right? But that closes the opportunity on discussing the details of your contract. So like I think one tip is important that if you invoke as an in-house counsel or in-house counsel negotiating together with your principal, you say, okay, let's do it Cheng Li, but make sure you step in as an in-house counsel and follow up. Okay, so what about date of payment? How many days? You follow up on the details. Then you get uh, all of the good things from it. Yeah.
Best of all the worlds. Well, that's a very good tip because I think the principle of good faith exists in many legal systems and also in just dealings, right? People want people who are forthcoming
Yeah.
and sincere and honest, and perhaps with clean hands as well. And yeah, and of course sometimes that means that parties sometimes forget to come to an agreement on certain things, like you
Yeah,
mentioned, date of payment, especially in situations where they loan
yeah.
money and they expect the
Also,
money to be paid and things like that. So I think that's very useful for counsel to remember.
yeah, also I think similar to Singapore, there is still a lot of seniority that you need to keep in the back of your mind, right? So that's why when Cheng Li is mentioned, usually the more junior person in the room tend to sort of, okay, this is where it ends. But I think this is useful if you're an in-house counsel, and even if you're a junior, even if you're the younger person in the room, still ask, oh, I'm sorry, but can we talk further about how we will do this?
Yeah, that's very useful. I realize in many Asian countries, especially, the seniority hierarchy makes a difference. And sometimes the juniors they find it hard to open their mouths to ask, to have more terms crystallized, for example. Yeah. Would you say that that translates also in contracts? Do Indonesian parties like long contracts, or do you think short contracts work better? I mean, this is a bit, we're segueing a bit from the conversation, but I'd just like to hear your take on this.
Oh, to me, I always prefer shorter contract, but um, because also, yeah, I want to operate in a way that we believe that we are a civil law country, even though there is an absence of civil code, the former translation of it. So there is an argument to make a long contract to cover everything that is not already written in the civil code, but it's also in the sort of, well, if I can mention the forefathers or the founding father of Indonesian law, Professor Supomo. He often say, like, being a civil law country, it doesn't mean that you have to write a long contracts and you have to establish every basis from zero, but you operate on the basis that there is a foundation, there is a civil code in the back of your mind. So a long contract is not actually required if we think optimistically about Indonesian law. Um, yeah, but yeah, there are still a debate about this. And when I interviewed litigators, they often say, "Oh yeah, the corporate lawyers, they like to write long contracts because they can charge more."
Yeah. More words, more.
But actually, in Indonesian court, if the contract is short, it's even better, because imagine the judges don't have time to read 300 pages contract. If it's a contract of 5 pages, they would understand. And it's also one of our required skill as a lawyer, right? We have to be able to boil down a transaction or a cooperation into an understandable language in the contract.
Yes. Yeah, to be concise to the specific main obligations and the rights and responsibilities that should be set out. Okay. Yeah, that's useful to know that it's a universal thing. And I think it's very important to know that, judges also are human, right? And if the things are spelled out clearly and concisely for them, that would be best. Thank you so much, Dr. Santy, for joining us on Regional Counsel. If you have found this episode helpful, please stick around to learn more with us. This has been Regional Counsel, a production by the Singapore Academy of Law. Thank you.